Hello, everyone, and welcome to this Privacy Rules Privacy Espresso. The Espressos today is a special episode to provide you with a brief overview on what is going to be discussed in one of the webinars hosted by one of our members. The topic is the new bill coming in Canada named Bill C-27 that is going to determine relevant changes in the privacy landscape in Canada. And we are going to do so with the Privacy Rules experts from Canada, from the law firm McMillan, that are Kristen, Pennington, and Mitch, Koczerginski, partners of the firm and members of their privacy and data protection group. So let's open it with a general overview. So what is Bill C-27 and how would it change the privacy landscape in Canada?
Thanks, Alessandra, and thanks so much for having us today. It's a pleasure to talk to you about this development. Currently, in most Canadian provinces and territories, the processing and protection of personal information in the private sector is governed by the Personal Information Protection and Electronic Documents Act, most commonly known as PIPEDA. PIPEDA is federal legislation. It applies across Canada, except in provinces that have enacted their own privacy legislation that has been declared substantially similar. At present, only Alberta, British Columbia, and Quebec has been declared substantially similar to PIPEDA. In June of last year, though, Canada's federal government tabled Bill C-27 with the goal of materially changing the legal landscape for privacy and data protection in Canada. If passed, would repeal the part of PIPEDA that governs the handling of personal information. It would enact the Consumer Privacy Protection Act, or the CPPA, as anticipated to be called. Bill C-27 would also enact the Personal Information and Data Protection Tribunal Act, which sets a framework for a new tribunal that would potentially have the power to impose fairly significant fines for organizations who do not comply with the CPPA. Now, we expect that these changes may also result in the amendment of substantially similar provincial legislation, particularly in Alberta and British Columbia. Finally, Bill C-27 would also enact the Artificial Intelligence and Data Act, which is intended to regulate international and interprovincial trade and commerce in artificial intelligence systems by establishing common requirements across Canada for such systems and to prohibit certain conducts that may result in serious harm to individuals or their interests.
Thanks a lot. Perfect. And to you, Kristen, what do you think has motivated the Canadian government to propose such a major overall provision in relation to the Canadian federal privacy legislation?
Thanks, Alessandro. So major privacy law reform has actually been on the government's radar for some time. And I think there's a grab bag of reasons informing the desire for this overhaul. So in addition to wanting to ensure that Canada remains competitive in a data-driven global economy, Canada's federal government has also committed to building Canadians' trust in the digital sphere, particularly in light of a number of recent high-profile data breaches that have impacted Canadians. Canada's federal privacy regulator has also long been vocal about the need for enhanced enforcement powers against organizations that mishandle Canadians' personal information. So currently, the regulator's powers under PIPEDA are pretty thin. It's mostly sort of a name and shame and non-binding recommendations that are made in this jurisdiction. And in particular, the regulator's been looking for a broader ability to level fines or other punitive measures against organizations that violate privacy legislation, like in some other jurisdictions. I think that a desire also to maintain Canada's adequacy under the GDPR, as well as keeping up with legislative developments in California and a number of other US states and in several countries across the world. In fact, Bill C-27 isn't the government's first attempt at overhauling Canadian federal privacy legislation. It's deja vu in a sense. So in November 2020, the federal government had proposed another bill that would have made a number of similar changes to those that are set out in Bill C-27. That particular bill died on the order paper because a federal election was called in the midst of it being debated. So really, this is the second attempt to push through these comprehensive amendments.
Wonderful, Kristen. And what's the current status of this bill?
So it's important to note it's not yet law. So on April 24th, the bill completed its second reading in our House of Commons. So the bill will now proceed to what we call the committee stage. So a variety of stakeholders, including the Federal Privacy Commissioner, who's already chimed in with some submissions to the Standing Committee on Industry and Technology about the form and the content of the proposed legislative changes. So still an opportunity to be heard, and the bill will still have to make its way through several stages before it actually becomes a law. If and when the bill passes through the committee phase, it will still need to pass a third reading in the House of Commons and then proceed to Canada's Senate, where it will need to pass through 3 readings before actually becoming a law. So I think the key takeaway is we're likely still a couple of years out. There's usually, in our experience, a buffer between when a law receives royal assent and when it actually comes into force. And it's also possible, as we've seen recently with the changes coming into force in Quebec, that there could be sort of a phased approach. In Quebec, the changes are coming into force over a 3-year period. So it's possible that we could see a similar approach with the changes proposed by Bill C-27. But with that being said, in our experience, it's never too early to start thinking about what these changes mean for your clients, for your organization, particularly because multinational organizations are being pulled in a number of different directions and trying to comply across so many jurisdictions. The earlier you start to think about these changes, the more likely you are to have sort of a smooth transition. And with that being said, a number of the changes proposed by Bill C-27 are actually codifying existing regulatory guidance. So really, organizations should be doing a lot of these things to best place themselves to respond to a privacy complaint or an investigation by the regulator. So it's not too early to get some of those changes going and starting to implement some of these best practices, even if Bill C-27 still has a long way to go before it comes into force, if ever.
Perfect. And last but not least, I would like to ask to the both of you, why should organizations doing business in Canada take note of Bill C-27?
Yeah, so I'll jump in. We obviously can't cover the whole gamut of the different changes that are proposed, but basically at a high level, Bill C-27 introduced a number of new requirements for organizations, both that handle personal information in Canada or about Canadians. For example, there would be a requirement to implement a privacy management program, and Bill C-27 would also establish new conditions to obtain valid consent to process personal information. There would also be new exceptions to the consent requirement, which is very significant because we are a consent-based regime. There would also be provisions to limit the obligations of service providers that handle personal information on data controllers' behalf, which would be a welcome clarification in the law. There would also be additional transparency requirements with respect to cross-border transfers of personal information, very relevant for multinational or interjurisdictional organizations, as well as transparency requirements around automated decision-making systems that would be introduced, and then also new data subject rights like a limited right to data deletion and also certain mobility rights. So by any means an exhaustive list, but it gives you a sense of just how major the changes would be if and when they are passed.
Yeah, and from my perspective, I'd add that the most notorious change that would come as part of the legislative overhaul is the introduction of meaningful teeth, which Kristen had alluded to. What I mean here is enforcement mechanisms that back up the requirements set out of the CPPA. By comparison, under PIPEDA, breaches generally don't attract statutory financial penalties except in very limited circumstances. And even then, the penalties are relatively modest as compared to those to be introduced under the CPPA. Under PIPEDA currently, the enforcement powers of the privacy regulator are largely limited to naming and shaming organizations that don't comply, as well as the authority to make non-binding recommendations. The CPPA would authorize the federal commissioner to make binding orders and recommend potentially significant and harsh financial penalties to a newly established Personal Information and Data Protection Tribunal. CPPA would also provide for a private right of action to facilitate individual lawsuits for contraventions of the CPPA, and this change could potentially enhance an individual's ability to recover damages from organizations for breaches of the CPPA compared to existing rights under PIPEDA, which essentially places a few obstacles in front of litigants seeking to collect damages for breaches of PIPEDA. The potential financial exposure that has been proposed under the CPPA is not insignificant. Under PIPEDA, there are fine caps at around 100,000 Canadian dollars, but certain breaches of the CPPA would constitute offenses that could be punishable by a maximum fine equal to the greater of 25 million Canadian dollars or 5% of the organization's global revenue in the prior year before sentencing. So, there are other fines as well, but just to give you a taste of it, the dollar figures at a maximum that we're talking about are quite alarming.
Absolutely, that's And thank you both for this update also, because it sounds like an extremely relevant change in the landscape. So Kristen, Mitch, thanks a lot for being here with us today, and thanks also to our audience for being with us today that I invite to join us in your webinar on Thursday 18. So thanks a lot, and looking forward to meet you soon. Bye everyone.